Here is my understanding of how you should write a case brief. I believe we were taught this in law school, but I did it so many times I kind of forgot what we were taught. Um, this is PowerPoint slides that I created for a case where we do I think, a very interesting study of an escaped slave case. Um, I'm hoping that'll show up there. That's lovely. Um, Eaton versus Vaughn, where a slave gets onto a steamboat and is carried down the river and eventually escapes. Anyway, we don't have to worry about that. If you want to read the case, which I find rather fascinating, historically, it's not pretty. It essentially says uh, slaves are property and must be returned, and that the captain of the steamship was careless in letting the slave get onto the ship. But basically, what we want to do is follow something they teach in legal writing. And you can see that this is utilized pretty uniformly in modern case opinion writing, that this is kind of a broad outline that we utilize. First of all is the event or the facts. Um, the law is very, very deeply driven by facts. If the facts are the same and there's a prior decision and that is well ruled, well reasoned, then case closed. Ordinarily is exactly what we're looking for. We want here to be neutral in our statement of facts. Oftentimes, as we read a case, we will begin to side with one side or the other, which can color our rendition of the facts. We may not be quite as neutral as we could have been. We want to, by neutral, I mean put all the facts in, even those that are not favorable to the side that we think wins or that the court ultimately decided wins. So each of you is going to be assigned a case, and you need to be able to write out the facts first, get all the facts in, be complete, be concise. It doesn't matter to me because I'm not going to be looking at whether that's bullet pointed or narrative. Whatever will make sure you can get all the facts out as best. Next is issue. What is the legal question? Now, there's very rarely just one issue in a lawsuit. As you're doing a case presentation, I would rather that you focus on no more than 3 different rules of law. Simply because of the time constraint in the project, we're not going to want you to talk for more than 8 to 12 minutes total. So that means try to narrow this to the 3 most important ones, or the 3 that build to one. And you can oftentimes find what these issues are in the head notes, although I hesitate to send you there because you really need more of the training a lawyer receives in order to fully understand what those head notes mean. Some students are able to do it. If you can and you think it doesn't jaundice you, please do. Bluntly, it's how I learned the law of negligence, was just reading head notes. I read the entire digest on negligence and read all the head notes on every category. By the time I got to law school, I really was pretty well versed in how courts reason things. But anyway, here we're looking at just state what is the issue. Then what we want to look at next is there a rule? Is there research, or is there a rule or a regulation, or is there an old ruling, an old case that either serves as precedent or is distinguishable? And generally when we mean distinguishable on the facts. The case we do the mock trial on is the Clark case. It's about rounding up steer. If there are cases about rounding up sheep, they may or may not mean the same thing. If rules or regulations about how to treat sheep generally have nothing to do with how to treat a longhorn steer. So, we want to be careful that we've found legal research that works for us. As we're looking at the precedent, is that correct? And in this project case presentation, I don't ask you to read other cases. I'm not trying to overburden you. It is what a lawyer would do. Every case cited by my opponent, I'm going to read. I'm going to read it very carefully to see if I can't distinguish it. Say, no, while that is what that court says, it says it for these reasons, not for the reasons upon which we're litigating, not for the issues upon which we're litigating. All right. The last part is analysis. Well, not the last part. The last two sections are analysis. And I've begun to deal with this a little bit. How do I differentiate this case that appears to cause me to lose? How do I get the court to say, no, that's wrong. This is how it should be. So we may argue, sometimes they call public policy, but we may try to look behind the law to see what its purpose is. What is the law attempting to achieve? Is that still something viable in modern society? Is that really where we want to be? Is that property right, such as slavery, still what we want? And what we may find is we're able to persuade the court by careful analysis how to move on. For you guys, here, maybe we don't need this. In the LRP, we need a little more careful. Conclusion. One of the things I always want to see students do is analyze whether the court was correct. Did it get it right? And then tell me why. Based on the fact that there were 4 very similar precedents, they all said X, Y, Z, and therefore, this case comes out X, Y, Z too. Give your reasoning. The purpose here is a case brief is something you could look at in class and utilize. It's something we did almost every day. We got to the point where we could just kind of do them in our head. We maybe had to write it out, maybe didn't, but ordinarily, once I read a case, I could just do it from memory. But I had to go through this process for a while before I was comfortable with doing it just that way. When I look at, so it's easier for me to look at my notes than it is for me to look in the case. But ordinarily, I have a slightly photographic memory, so I can remember where it might be in the case. But this gives you a broad outline from which to build your slides. So that's basically how I think you do a case brief.